My rant for the day, as I said, I'll just summarize it here for you, is that there are two standards of justice that were presented in the Trayvon Martin case. And my apologies for, apparently I referred to him as Trayvon Williams earlier in the day. And thank you, tip of the hat to the folks in the chat room for pointing that out. It's been a wild week. Ever since a Seminole County, Florida grand jury found George Zimmerman not guilty on Saturday night of murdering Trayvon Martin, many commentators in the mainstream media have made a special effort to point out that Florida's so-called stand your ground and shoot first law played no role whatsoever in Zimmerman's acquittal. Do you have this Chris Cuomo clip? Yeah. Here, for example, is a clip of CNN's Chris Cuomo discussing or dismissing Stand Your Ground's impact on the case during a Sunday broadcast less than a day after the jury announced its verdict.
Stand your ground. We all talk about it. It did not play a role in this jury's verdict. They didn't need to use that law. It wasn't even argued.
Yeah, Chris is just wrong. Stand Your Ground isn't some standalone law. It's a complete modification of Florida's rules governing the use of deadly force for self-defense. And as a result, it played an essential role in the Zimmerman trial. In fact, two different standards were used. They weren't created by the Stand Your Ground law, but two different standards were used by which the six jurors judged both George Zimmerman and Trayvon Martin. As former Florida Secretary of State Dan Gelber has pointed out, pre-Jeb Bush, pre-Koch brothers, and pre-Alec Florida law would have required the following instructions to be read to a jury in a self-defense murder trial. Quote, the defendant, George Zimmerman, cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. The fact that the defendant, George Zimmerman, was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating he could have avoided the need to use that force. End quote. That's the old law. That's the old jury instructions. Note that according to those jury instructions, the defendant has to do everything possible, including retreating, before attempting to use deadly force. When confronted with a threat in 2005 and before, whether it was a deadly threat or just the threat of violence, or even when confronted with actual violence, like being punched in the face or knocked to the pavement, the legal obligation was to work yourself free and run. All that changed in Florida in 2006 when the state's brand spanking new and ALEC promoted Stand Your Ground and Shoot First law came into effect. Since 2006, post-Jeb Bush, post-Koch brothers, post-NRA and ALEC, the Stand Your Ground and Shoot First concept has become fully integrated into Florida's law regarding self-defense and the use of deadly force, which is why the jury instructions for Zimmerman and for his jury included Stand Your Ground language, because that language is now part of Florida's laws about self-defense. I mean, listen carefully to this. This is the difference between the you must retreat language, which I just read to you in the pre-2006 jury instructions, and the instructions used in the Zimmerman trial. Remember, before 2006, Florida law said that even if the other guy started the fight, you still had an obligation to run. The old law reads as follows. Quote, the fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating this is the old law, if by retreating he could have avoided the need to use that force. By comparison, here are the two Stand Your Ground instructions that actually were read to the Zimmerman jury. Quote, the danger facing George Zimmerman need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, George Zimmerman must have actually believed that the danger was real. George Zimmerman had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself. George Zimmerman did not even have to have a threat of deadly force used against him. All he had to do was believe that there was such a threat. And instead of running, he could stand his ground and shoot first to kill, which is what he did. Even more interesting than that, though, is that both in the actual Zimmerman trial and in the trial conducted in the American media, both Trayvon Martin and George Zimmerman were essentially on trial. In the courtroom proceedings, Trayvon Martin was being judged as part of Zimmerman's self-defense argument. The defense asked, why didn't he run away from Zimmerman? And because Martin didn't run away, Zimmerman's lawyers suggested that Zimmerman was justified in killing him. This was so explicit in the trial that defense attorney Mark O'Mara even asked for 4 minutes of silence during his closing arguments, as if to demonstrate that Trayvon Martin had plenty of time to turn and run.
We're going to take a break, but before we take a break, here's what I'm going to do. We're going to sit tight, and we're not going to talk. And I'll tell you when we'll talk again, okay? That's how long Trayvon Martin had to run. About 4 minutes. When he said he was running, that's how long he had.
And in the media trial of Trayvon Martin, commentators have repeatedly asked, why didn't the 17-year-old just run away from the armed man who was chasing him? You know, as one of Florida's most famous white pastors, Bill Keller, argued in a nationally published op-ed, quote, the facts were clear that Trayvon Martin had more than enough time to get back to his father's house, but chose instead to confront Zimmerman, break his nose, and continue the violent attack. End of quote. In other words, Trayvon Martin should have run away. So the question, why was Trayvon Martin judged both in the trial and in the media on the basis of the pre-2006 Florida self-defense law that requires a person to do everything they can to avoid violence up to and including running away? And equally troubling, if that was the standard that Trayvon Martin was held to, why was George Zimmerman, who actually held the gun and fired the shot, held to a different standard and allowed to stand his ground and kill an unarmed teenager without penalty? Remember, nobody ever seriously suggested in the trial or in the media that Trayvon Martin had a right to stand his ground. Instead, everybody wanted to know why he didn't run. And remember that over and over again in the media, George Zimmerman's lawyers and Judge Nelson herself explicitly said that George Zimmerman had the legal right to stand his ground and use deadly force if he even felt threatened. While Trayvon should have run, Zimmerman didn't have to run. Remember the actual instructions that Judge Nelson read to the jury about the standard to which George Zimmerman should be judged? George Zimmerman had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force. Why were George Zimmerman and Trayvon Martin judged by different standards? Inquiring minds want to know.